Hey everyone, welcome back to the Texas Business Court Insider. I'm Rafe Schaefer.
And I'm Kate Ergenbright. And today we're going to be revisiting a topic we initially discussed last spring, Texas's Senate Bill 29, which is a major new corporate governance statute passed by the Texas legislature at the end of the last legislative session and signed by the governor into law at the beginning of this last summer.
Texas companies have now had a little over 6 months to take advantage of SB 29, so we're going to take a look at some of the trends we're seeing on how companies are incorporating SB 29's provisions into their bylaws.
Before we get there, Rafe, can you remind us what SB 29 is all about?
Sure. So SB 29 or Senate Bill 29 was Texas's attempt to Delawareize its corporate governance code. It implemented various procedures and was really wide-reaching. It codified the business judgment rule in Texas. It codified various safe harbors. It created procedural mechanisms whereby companies could get court input on the front end of transactions on whether or not they were conflicted transactions. And then it also implemented a host of provisions that companies could implement into their bylaws, their corporate bylaws, to try and protect themselves or protect the companies in future disputes with their shareholders. Kate, why don't you talk to us now about, on that latter point, how are we seeing companies actually implement some of those protections?
So understandably, we have the most visibility of what public companies are doing. And there are three aspects of Senate Bill 29 that we are seeing public companies incorporate the most. One is a jury trial waiver. The second is a forum selection provision in their governing documents. And the third is a derivative shareholder litigation limit, which limits the type of shareholder that can bring a derivative suit by limiting the amount of shares the shareholder has to own before they can bring a derivative claim.
So starting with the first, the jury trial waiver, SB 29 had some interesting provisions on when and against whom that jury trial waiver is enforceable. A jury trial waiver has to be knowing and informed and voluntary. And so a company can't go and implement a jury trial waiver retroactively against its shareholders unless the shareholders vote for it. And so one of the ways a jury trial waiver is enforceable is if the company submits the jury trial waiver to its shareholders and they vote for that waiver. If they vote against it, it's not enforceable against them. But if they vote for it, it becomes enforceable against them. The other way it's enforceable is if the company implements a jury trial waiver and the shareholder buys those units or buys shares after the jury trial waiver is in the bylaws. In that case, it's knowing and informed and voluntary. It'll be interesting to see as the disputes continue to develop. Are there instances where a shareholder owns shares that aren't subject to the jury trial waiver and then buys additional shares that maybe are subject to the jury trial waiver? How does that work? How does that get litigated? We'll obviously continue to monitor and see if that situation arises. Kate, do you want to talk to us about the second component, forum selection provisions?
Sure. So the trend that we're seeing is that public companies that are implementing SB 29's forum selection provision are choosing both a specific district of a federal court in a specific location and then a division of the Texas Business Court for those cases that are not going to have federal court jurisdiction. These forum selection provisions generally apply to internal affairs type claims or the shareholder derivative suits that Rafe is going to tell us about in a few moments.
So on those derivative litigation limits, this is certainly one of the more interesting aspects of SB 29. SB 29 allows a corporation to limit the ability of its shareholders to bring derivative suits. It allows them to implement caps on who would have standing to bring a derivative suit. They can't make the cap higher than 3% ownership. We've seen a number of companies implement these derivative litigation limits in their bylaws. We've seen at least one case in federal court in the Northern District of Texas where a publicly traded company is relying on the derivative litigation limit to move to dismiss a derivative suit. The plaintiff in that case, who purports to bring the case derivatively, has responded and asserts that SB 29, or at least that part of SB 29, is unconstitutional. It's very interesting. That hasn't been resolved yet. Certainly there will be other disputes about SB 29 and this derivative litigation limit that we'll continue to monitor.
Yeah, I noticed, Rafe, there was at least one public company that had disclosed this amendment to SB 29, the limitation on shareholder derivative suits, in their 10Q as a potential disadvantage to its shareholders as compared to the shareholders of a Delaware corporation, which is it's a really interesting way to put it. And that company ultimately, after filing that 10Q, did incorporate the derivative litigation limits that was referenced.
So even that, Kate, I mean, it raises a lot of interesting questions about fairness doctrines, business judgment, conflicted transactions, all of those kind of classic internal affairs disputes that we've seen over the years, will probably arise and come up under SB 29 and the Delawareification of Texas's corporate governance code. We're super excited to continue to watch as those develop, watch as those new cases get brought. We'll be reporting on, this constitutional challenge when it gets decided here at the Texas Business Court Insider.
Thanks for watching Texas Business Court Insider. Be sure to hit like and subscribe to get notified of our new videos. Don't forget to check out the Texas Business Court Insider Hub via the link below this video. It's packed with resources to help you navigate the Texas Business Court and new developments in Texas law, such as SB 29.